Have you ever thought about what happens inside a company when the people at the top start making decisions that, well, mostly just help themselves? It's a classic power dynamic, right? Today, we're diving into the legal toolbox for the underdog, the minority shareholder. We're going to look at exactly what they can do to fight back and make sure their investment is protected.
So, here's our game plan. We'll kick things off with the fundamental rule of corporate life. The majority gets to call the shots. Then, we'll explore the dark side. What happens when that power gets abused? After that, we get to the really good stuff. All the different ways shareholders can fight back, leading us all the way to the specialized courts where these corporate battles are actually fought and won.
You know, you can think of a company almost like a small democracy. For it to work, for decisions to get made at all, someone has to have the final say. And in the business world, that's the majority of shareholders. This isn't just a friendly suggestion. It's the bedrock principle that allows a company to function and move forward without being stuck in endless debate.
And this idea has been around for a long time. I mean, way back in 1843, a famous case, Foss versus Hartable, basically laid down the law on this. The court said that if someone wrongs the company, it's the company itself that has to sue, not just any random shareholder. And that makes sense, right? It stops one person from constantly dragging the company into court. But it also means the majority is holding all the cards.
So the majority rule exists to keep things orderly and prevent chaos. But what if the chaos is coming from inside the house? What happens when the very people who are supposed to be protecting the company are the ones causing the harm? Well, that's when the whole conversation has to shift to protecting the minority.
Right, so this is where things get tricky. When that power is abused, it can turn into something the law has very specific names for: oppression and mismanagement. And trust me, these aren't just fancy words for a boardroom disagreement. They are serious legal concepts that can cause real financial harm.
So what does oppression actually mean? Think of it less like a single punch and more like a constant grinding pressure. The Supreme Court, in a major case, Shanti Prasad Jain versus Kalinga Tubes, explained it perfectly. It's not about one single bad decision. It's a pattern of behavior, a continuous series of acts that are burdensome, harsh, and just plain unfair to the minority. It's about being systematically sidelined.
Mismanagement, on the other hand, is a little different. While oppression targets a specific group of shareholders, mismanagement is about hurting the company as a whole. A classic example, a director using the company's bank account like their own personal piggy bank. That doesn't just hurt the minority shareholders, it hurts everyone and damages the entire business.
Okay, so we've laid out the problems, oppression and mismanagement. Now for the exciting part. How do you actually fight back? The first weapon in the arsenal is the shareholder lawsuit. And these aren't your typical lawsuits. They're specially designed to get around that majority rules roadblock we talked about.
All right, so you've basically got two main legal moves. First is a derivative action. This is where you, a shareholder, step up and sue on behalf of the company. Let's say a director is stealing, but the board refuses to do anything about it. You can step into the company's shoes and file that lawsuit yourself. Then there's a representative action. This is when a bunch of shareholders have the same complaint. Instead of everyone filing their own lawsuit, you band together and sue as a unified group. Now, lawsuits are a powerful tool, no doubt. But the law itself gives shareholders an even bigger shield. The Companies Act of 2013 is packed with provisions specifically designed to protect minority shareholders. And honestly, they're a total game changer. And the absolute cornerstone of these protections? You gotta know this one. It's Section 241. This is a huge deal. It gives minority shareholders a direct path to a special court, known as a tribunal, whenever they feel they're being oppressed or the company is being mismanaged. It's so powerful because it's not just about winning money. It's about getting the court to step in and stop the harmful behavior in its tracks.
Now, of course, you can't just sprint to the tribunal every time you disagree with a decision. There are thresholds you have to meet. You need a certain number of shareholders or to represent a certain percentage of the shares. But, and this is the really cool part, the tribunal can actually waive those requirements if they think the case has merit. So even if you don't have the numbers, you still have a shot at being heard.
And if you get your case in front of the tribunal, what can they actually do? Oh, a lot. They have sweeping powers. They can literally regulate how the company is run going forward. They can force the majority to buy out your shares at a fair price. They can fire the problem directors. They can tear up unfair contracts, you name it. The goal isn't just to punish past wrongs, it's to actively fix the company. So, we've seen how even a small group of shareholders can make a stand. But what happens when you're not just facing a few bad actors, but a massive corporate machine? Well, sometimes you gotta bring in the big guns.
I mean, it can feel like a real David versus Goliath situation, can't it? Just you, a single shareholder, going up against a huge corporation with unlimited resources. Sometimes a slingshot just isn't going to cut it. You need a whole army on your side.
And that's where Section 245 of the Companies Act comes into play. This is the legal basis for class action suits. It's the ultimate strength in numbers play. It lets a huge group of shareholders, or even depositors, who've all been wronged in the same way, team up and file one massive lawsuit. This gives a powerful voice to people who, on their own, might never have had the resources or the courage to fight back.
Okay, so we've talked about all these legal weapons in your arsenal, but where do you actually go to fight these battles? Who is the referee in this corporate showdown? Let's take a look at the courthouse.
You see, these cases don't just go to any regular court. They go to a highly specialized body called the National Company Law Tribunal, or NCLT. And this is a really big advantage, because the judges there are experts. They live and breathe corporate law every single day. They understand the complexities, which means you get a much more focused and streamlined process. And of course, if you disagree with the NCLT's decision, there's an appeals court, the NCLAT.
So there you have it. We've seen how the law attempts this delicate balancing act between the power of the majority and the rights of the minority. From fundamental principles to powerful lawsuits and specialized courts, there's an entire framework designed to protect the little guy. But here's the final question to think about. Is it enough? In a world of powerful boards and corporate giants, does the law truly create a level playing field for everyone involved?